This, or do we have enough?
We need 7 for a quorum
Here's Kevin right here.
for the legislation.
Okay, so 1, 2, 3, 4, 5, 6, 7. Yeah, we got it. 7, 8, 9. There we go.
Yeah, so you're good.
Okay, so I need to make an announcement. Apparently, somebody lost their cell phone or left their cell phone up in the breakfast room. Brad has it. If you don't remember whether or not you have your cell phone, you might want to check right now. Looks like a CalPERS phone, actually. Okay, so that's that piece of business. Oh, we figured it out?
Yeah, it's Kara.
Okay, cool. All right, good morning, everyone, and thank you for joining us on our final day of our Board of Administration and Executive Team Offsite meeting. Once again, the meeting is being streamed online, and members of the public are welcome to make public comment. Again, calling in at 1-800-259-4105. Members of our stakeholder relations team will be standing by to assist. Some quick agenda preview. After some of our normal routine business this morning, we'll launch into fiduciary training, followed by a presentation of the results of our annual stakeholder engagement survey. Our last order of business in the open session is an action item on Senate Bill 351 regarding private equity firms' involvement with healthcare practices of the organizations they have ownership in. And we'll adjourn our public session after that and conclude our meeting with a closed session to discuss pending litigation matters. But before all of that, can I have roll call?
Teresa Taylor,
Here.
David Miller. Here. Deborah Gallegos from Malia Cohen. Michael DeToy. Frank Ruffino for Fiona Monk.
Present.
Lorena Ortega. Jose Luis Pacheco. Kevin Pauke. Ramon Rubalcaba. Yvonne Walker. Melissa Willette. Dr. Gail Willis.
All those that weren't here are excused. With that, if Mr. Miller, our vice president, is ready, I'm going to turn the meeting over now for our action items on the proposed decisions of the administrative law judges.
Hey, thank you, Madam President. I move to adopt the proposed decisions at Agenda Item 8A1 and 2 with the minor modifications argued by staff, and to deny the petition for reconsideration at Agenda Item
That's a second,
8B1.
I need a second. Okay, I need a second from the board. Okay, the motion's been made by Mr. Miller, seconded by Mr. Pauke. All those in favor, say aye.
Aye.
All those opposed? If there's any abstentions. All right, that passes
Okay.
unanimously.
Thank you, Madam President.
Thank you. Next, action item is board travel approvals. Can I have the pleasure of the board? Moved by Mr. Miller, seconded by Mr. Pauke. Again, all those in favor say aye.
Aye.
All those opposed? Any abstentions? Motion passes. And boy, that was fast. We are moving on to our fiduciary training. Our presenters are Tiffany Reeves, partner of Fagre and Drinker, and Mr. Robert Carlin, CalPERS senior attorney. And this training focuses on trustees' core duties on the Bagley-Keene Open Meeting Act. Our presenters, again, Tiffany Reeves, Robert Carlin, take it away.
My talking points up. So most of you know me. I'm Tiffany Reeves. I'm a partner at Fagre Drinker, and I lead our institutional investor practice. And you know Robert as well. And so thank you for that introduction. I am excited to be here and have this conversation with you. It's great to be in Monterey, and it's always great to talk about my favorite topic, which is fiduciary duties. We had a great discussion last year, so some of this will be a refresher for those of you who were here last year. And if you recall last year, there were so many great questions. And so I love the sound of my own voice, but you might not love it. So I would love to hear your questions and have this be more interactive and dynamic so that you don't have to listen to me kind of drone on about fiduciary duties for the next hour. So one of the things that I find about fiduciary trainings is they often focus on what fiduciary duties are, what the duty of loyalty is. And when I first started doing this work, I used to, maybe as 15 plus years ago, I used to have these slides that had like the text and the bullet points about fiduciary duties, and I would quote Cardozo and use Latin words, and it doesn't really resonate, right? Because what you're really interested in is the practical application of fiduciary duties, what they are, why are they important, and how do you use those in your daily life? So we're going to start with the basics, what what fiduciary duties are, and then kind of move into how you apply them. That's the important part, the how. And then also talk about governance, because governance is really the other side of the coin. Fiduciary duties and governance. Governance is the execution. You know what your fiduciary duties are, and then governance is the how. So let's start with the basics, and again, encouraging questions today. You guys are so far away. I can barely see you. So, starting with the basics. So what is a fiduciary? So a fiduciary is a person who has the authority to make investment or administrative decisions related to the retirement plan. So that can be either a named fiduciary. So you all are named, or at least the board composition is set forth in the statute that's applicable to you. But a fiduciary can also be a designated fiduciary or a fiduciary by function. So by virtue of your role, you are performing duties that require discretion. And because of your discretion, you are a fiduciary. And so fiduciaries to CalPERS might include, obviously include board members, certain executives, certain CalPERS team members who exercise discretion. But they also will include investment managers, investment consultants, and then certain other professionals who agree to be a fiduciary by contract. On the legal side, we try to make everybody a fiduciary by contract, but sometimes it doesn't make sense if that person isn't exercising discretion. So one of the things that I found as I travel the globe talking about fiduciary duties and people ask questions of me about fiduciary duties is that there's a lot of confusion about the term fiduciary. And the term fiduciary means different things to different people in different contexts. And so it's important not to oversimplify that. So you should understand the complexity between the variances in different global legal frameworks and the duties that are applicable to different types of fiduciaries. And so, for example, public pension fund fiduciaries in the US are subject to the highest standard under the law. And so the standard that you're subject to as a public pension fund fiduciary is different than the standard that's applicable to a foundation or an endowment fiduciary. It's different than the standard that's applicable to corporate directors. They're subject to similar duties, duty of care and duty of loyalty, but they're applied differently. Also, investment managers are subject to the registered investment, to the Advisors Act. And so the registered investment advisors are subject to kind of what's called a best interest standard, which is different than the standard that you're subject to. But the key difference between this fiduciary standard that you're subject to and all other fiduciary standards that you might run across in your life is the tolerance for conflicts of interest. There is no tolerance for conflicts of interest for a public pension fund fiduciary. You are subject to the highest standard under the law, so that's the key distinction. So I just find that that's often a source of confusion, particularly for stakeholders and for the media, is that fiduciary duties mean something different to different people. So what are the sources of fiduciary authority for you as CalPERS board members? You already have a question.
Yes,
I love
ma'am.
it. Okay,
Thank you.
go ahead.
Yes, thank you. So back to the highest standard that we're at the highest level beyond board directors of corporations, beyond endowments and foundation. When you mention that, how does that apply to the standard of care with respect to that? Do we also have a high prudent standard of care as well?
So when I'm referring to the highest standard of the law, I'm referring to the duty of loyalty.
Do we loyalty?
And what that means is that corporate directors, registered investment advisors, they're subject to the best interest standard. Essentially, you are subject to the sole interest standard. You're required to act solely for the exclusive benefit of the participants and the beneficiaries.
So thank you for that clarification.
Absolutely. So again, grinding through the basics, happy to take on any questions. So starting with, what are the sources of fiduciary guidance for you as CalPERS trustees? The first one is Article 16 of the California Constitution and the Public Employee Retirement Law. So your state constitution and your state statutes are your primary source of guidance on fiduciary duties. But there's a number of other sources that we look to in interpreting your fiduciary duties where your statutes are vague or ambiguous. So these types of authorities can help you kind of fill the gaps when you're making hard decisions, but your statute doesn't define kind of the roadmap for you in making those decisions. So the first one is the restatement of trust, which you'll hear me talk about a lot today. That is a really important source of fiduciary guidance, and basically it's a treatise that is the source of guidance for courts as they're determining the application of fiduciary duties, and also all the model codes that you see, which sometimes are adopted by statute in different states, derive from the restatement of trust. Then you have ERISA. And you've probably heard from me in the past and from other counsel that ERISA is not binding authority on governmental plans. That's the retirement law, or the federal law that's applicable to private pension funds. But it is persuasive authority for public pension funds. So again, as a gap filler. So when the law is unclear or ambiguous in California, your attorneys are going to look to the ERISA guidance and ERISA case law to try to determine what a court might decide in a California case. So I already referred to court decisions. That's another source of guidance. We're going to talk about some court decisions today as well. And you'll hear me say, well, these are not, directly binding on you as a California retirement system, but it gives us some guidance on how a court might look at these issues because this is how they've decided it in other jurisdictions. The practices of similar fiduciaries are really important. So looking at peer practices, understanding what your other boards do, how they make decisions, what they've deemed to be prudent is an important part of a fiduciary process. And it's important to remember that looking at peer practices is an element of your decision-making process, but it's not dispositive of your decision. And what I mean by that is that pension funds are unique, boards are unique, your external circumstances, your funding, your liquidity needs, everything's unique. So you look to other practices as a source of guidance, but it's not binding on you. I mentioned model codes already. Yes.
Madam Chair. So can you just repeat that last sentence? It's looking to peers is, can you just repeat that?
So you look to other peer, and that include all kinds of different types of investors, both U.S. and non-U.S. But you look to them as a source of guidance for what's prudent.
Right. Okay.
but you also take that information in the context of your unique circumstances.
We're unique. So we may not find examples of exactly what we're doing amongst our peers, but that doesn't mean we shouldn't be doing it.
Right. However, if you are acting in a way that is not aligned with peer practice, you should have a reasonable basis for doing so.
Right.
So in some of my presentations, I have a slide of lemmings, jumping off of a cliff, because I think it's an important visual, even though I heard that that's actually a myth. But that you shouldn't follow your peers off the cliff. If there's a reasonable basis for doing something different, you should do it your way.
Right. Great. Thank you.
And then the last one on here is my personal favorite. The advice of legal counsel is always a great source of fiduciary guidance, whether that's me or other outside counsel or your in-house counsel as well. So what are your core fiduciary duties? As you know, there are a number of core fiduciary duties. Some of them are outlined in statute. Some of them can evolve from case law. But your primary duties, and what we're going to talk about here today, is the duty of prudence and the duty of loyalty. And the reason why those are your primary duties is because all of your other duties derive from the duty of prudence and the duty of loyalty. So, for example, the duty to diversify is codified in California. But that is a duty that really derived from the evolution of investment practices and the evolution of modern portfolio theory, and perhaps where we're even evolving beyond that theory, is that, but anyway, as a function of evolving in the complexity of modern portfolios, they determined that the duty to diversify should be codified, but really that derived from the duty of prudence. You have the duty to provide information. This derives from the duty of loyalty. So fiduciaries should avoid conflicts of interest, and they should communicate material facts to the participants and beneficiaries. And this duty really highlights the importance of transparency and providing good and credible information. Obviously, trustees must apply with applicable law and with the trust documents. And then we'll talk about co-fiduciary duties a little bit on a later slide. So one really unique thing about California is that you have this constitutional provision in California that says that the duty of loyalty, that's the duty that you as a board owe to pension participants and beneficiaries, shall take precedence over any other duty. And this is the primary duty rule that's in the Constitution, and it derives from trust law. And it was adopted in California specifically in an effort to prevent political meddling and other outside influences from influencing decisions for the trust. And that's something that's very unique in California, is that you have this constitutional provision. So let's drill down a little bit more on the duty of prudence. So the duty of prudence is forward-looking with a focus on diligence. And so that means that trustees and other fiduciaries are not judged in hindsight on the success or the failure of a decision. Of course, you've probably experienced that you're judged in hindsight in other ways, and through media scrutiny and otherwise. But when it comes to the decision and from a legal perspective, you're not judged in hindsight on the success or failure of a decision. What you're judged on is the prudence of the process that you undertook at the time that you made that decision. And so this means that the dissection of prudence is contextual, which is why we focus so much on process. You probably remember that from last year. It's, I'm like a broken record. What was done at the time the decision was made that informed the decision? That's what's important. So the restatement of trust modernizes the guidelines for fiduciaries in managing trust decisions. And a key governance practice in establishing prudence is
Tiffany?
investigation of material facts.
I've got a question here.
Oh, sure.
Thank you. I have a question about process, and I know there are instances or cases where the process is essentially laid out in the defense of the entity that's being challenged on a fiduciary duty issue. From like just thinking about the process that our board uses, how should we think about public process versus like closed session process and discussions that happen about issues that we may have concerns about, but some parts of it are in a closed session versus an open session, and the record that we're creating of the process that we used?
Well, it's important to document your process, and whether that's an open session or a closed session, and demonstrate so that you can demonstrate, if you ever have to, the diligence that was done. But a lot of times, because of confidentiality and other reasons, that process can't happen in public. I think there's a I'm going to show this slide just because maybe it's relevant to what you're talking. When you're thinking about diligence, there's usually so much diligence that's happening behind the scenes. From a CalPERS team perspective, the work that they're doing, the consulting with outside experts, the testing and rethinking before it kind of bubbles up to the point where you're making the decision. So there is going to be a lot of things that's happening below that waterline. But the important thing is that your governance infrastructure is formal and accountable, and you have policies, procedures, things that are happening in the background that are informing the decision that you make that's above water. That's the piece that the public's going to see when you're voting in open session. And the important thing, I think, from a legal perspective, is that everything that's below the water is happening and is documented and is formal, repeatable processes.
Okay, thank you.
Thank you, Tiffany.
If I might add to that, as far as defending a decision in litigation down the road, the record would consist of both what is provided in open session and what is provided in closed session or discussed in closed session. It might just be that the closed session material, in terms of providing it to the court or to the other parties, would be subject to some kind of a confidentiality agreement or some kind of protective order so that it's not publicly disclosed, or maybe by that time the importance of the secrecy would have lessened, so it can be provided. But the whole record will be available for the defense of an action.
And you all might recall as well that last year we talked about the importance of a well-sequenced process. And what that means is that the facts should inform the decision and not vice versa. You can't reverse engineer prudence. And when you're thinking about this, even from a litigation perspective, there are good facts and there are bad facts. Good facts look like a well-defined process that was informed and that informs the decision rather than a decision that informs the process. A trustee who has special skill or expertise has a duty to use that skill or expertise. In California, you have a prudent expert standard. So that, and this goes to your question earlier today, is that, so if you're a banker or an auditor or a lawyer, for example, and you have special expertise, you're held to the standard of a banker or a lawyer or an accountant who's in a fiduciary role. So your expertise should inform your decision making. And then if you do not have the expertise, then you have an obligation to use outside experts and even internal experts to help inform your decision making. Under the prudent investor rule, delegation is permitted. So as long as trustees use reasonable care in selecting the agent, defining the scope of the delegation, and then continuing to monitor the agent, then you've exercised prudence. Yes.
Sorry, I do have a question back to the use of the special skills or expertise. And with respect to that, you mentioned that it's very unique in California. Is that correct? What you mentioned?
No, the prudent expert standard is the standard both in most states and then also under ERISA.
And you mentioned that if an individual already has this expertise, a banker, a CPA, an accountant, that they should utilize their services, their expertise and their skill, their domain expertise. And if you don't have those skills, then seek out outside counsel. However, is it also reasonable to say that trustees in general should also get more education? Get educated on those particular items and elevate their level to from a layperson up to a higher standard. If you can elaborate a little bit on that.
Yeah, that's a good point. Continuing education is a key part of a prudent process, and a lot of times, I understand that you all do this as well. Is like when you're making an important decision, or it's coming down on your annual calendar, doing relevant education before you're making that decision. You have an ongoing obligation, like most professionals, to continue your education, to identify any gaps in education, and use your internal and external resources to help fill those gaps.
Excellent. And thank you for bringing that up, because I feel that's very important in terms of now we're entertaining the consideration of the total portfolio approach, which is a very complicated and very complex, investment vehicle, an approach that we have not, has not been taken into account, and having more education on that area is prudent. Thank you for that, your elaboration.
Absolutely, and that's a perfect example of how dynamic prudence is as well, right? Is that investment practices continue to evolve over time as information gets better and as circumstances change. And so, there's a statement, it's probably in my slides. My computer's turned off, but it's still pinging, I'm not sure why. There's a statement, I think later in my slides, that talks about some guidance from the restatement that says that trustees should avoid freezing their knowledge as a moment in time and have a continued obligation to continue learning, and that your investment practices should evolve with better information and changing, evolving peer practices. And so TPA might be a good example of that.
And I just want to go back to the previous previous slide. It was the one on the retirement board duties is a participation. The beneficiaries shall take precedence over any other duty. And you mentioned that in California, it was meant for to prevent any political meddling. And is that unique in California?
The codifying the primary duty is unique in California. Yes.
So we should. So our level of prudence, our level of duty of loyalty is to be very independent in terms of how we evaluate things, not to let political meddling or influences our influences, or any agents influence our decision-making process.
Correct. The duty of loyalty means that your primary duty is to act exclusively in the best interest of the participants and beneficiaries over the time horizon that you have deemed to be material. So that's to the exclusion of all other interests.
To all other interests. And can you elaborate on what those interests may be?
Absolutely. I have a great slide on that. And so
I look forward to that.
Table that question, and then we'll really drill down on those in a few minutes.
And Tiffany, I'm sorry, I just want to make sure that our board and everybody knows that we provide 24 hours of education, 42, a lot of education at the board itself, at CalPERS. It's not necessary for all of our board members to have to seek education outside, because anything that is new, such as TPA, we do provide education for that here at CalPERS. So I just wanted to make sure everybody was aware of that. It's and not misunderstanding that means you have to go out someplace and find education.
Are you saying that there's somewhere else we should be going for education, or do you mean just what we've seen yesterday, for example?
Yeah, yesterday, for example, I think we see, Stephen's given us, like every time we meet, education on
But if somebody
TPA.
feels like they need additional, they can seek
Absolutely,
that.
or they can sit down again with Stephen or one of the investment staff as well.
Thanks.
Specifically, so by statute, the board members are required every 2 years to have 24 hours of, at least 24 hours of continuing education. Staff goes out of its way to make sure that we provide a number of sessions that would qualify for that just internally, so that there's not a need necessarily to go further. TPA is a great example because Stephen has provided a number of both open and closed session presentations to help concretize what that's going to look like and help the board understand that. And so those are good examples.
Then also that's going to mean different things to different trustees, right? And so you also need to identify your gaps and seek out whatever resources CalPERS has to help you fill those gaps in education. And we all know, right, where are the things that we're really good at and the things that we're not so good at. And it sounds like CalPERS has a resource for that. So let me bump forward a little bit past the slide. We talked a little bit about the prudent expert standard, and that's codified in California, both under the Constitution and then also under the Public Employee Retirement Act. And so I won't spend too much time there. This is my only text slide, but I thought it was important to make sure that the exact standard is reflected in your materials. So the key takeaway from the duty of prudence is that it's process oriented, it's forward-looking. I mentioned before, you can't reverse engineer prudence. You have to do the work. And I think that this slide is just kind of a good representation of your earlier question about all the diligence that has to happen before you get to the point where you make a decision. So let's move on to governance and talk about that a little bit. So as I mentioned in my introductory remarks, is that good governance practices support the duty of prudence and the duty of loyalty. So formal and accountable governance practices provide appropriate guardrails that support decision-making and establish expectations in advance of challenging situations. And I can't stress enough how important it is to establish your governance practices in advance of a crisis. You should have rules of the road that help you navigate that crisis. It makes your organization more resilient. And good governance practices are the bridge between what your fiduciary duties are, prudence, loyalty, and the execution of your fiduciary duties. We'll talk a little bit later in the slide about the framework that I like to think of, that I like to use is what, why, how. The governance is the how. This is the infrastructure, the formal infrastructure that you've developed to execute on your mandate. And the formality of that is really important. The foresight, the planning, the consistency. You can't just make it up as you go. You have to have done that work in advance of making decisions. So what is governance? Governance is basically the body of rules and practices and processes that facilitate the execution of your fiduciary duties. Board decision-making is a collective process, and it's important to remember that no individual trustee has the authority to take action on its own or to unilaterally instruct a staff member unless that authority has been delegated. So good governance requires structures, policies, procedures, and at the end of the presentation, we'll talk a little bit more about frameworks. It's important to note that several studies have shown a substantial return differential in favor of better governance. And there's a few statistics on this slide here. And so during this time period, in this one study that this is referencing, good governance practices were shown to have resulted in outperformance of 1% to 3% annually relative to peers in that group who had some poor governance practices. And so although trust entities operate under similar structures, it's important to remember that governance is one size fits one, to your earlier point. And so each organization should develop its own policies, practices, procedures, processes that are unique to the characteristics of that organization. So let's talk a little
Before
bit.
you move on,
Yeah.
could you go back to the previous slide? So you had said board decision-making is a collective process, so no one has the authority to act on their own. Can you put that a different way by saying no, every board member is equal in their fiduciary responsibility? Like my fiduciary responsibility isn't greater than his or her fiduciary responsibility.
Yeah, I think that's an accurate statement, that each of you individually is responsible for your own actions and accountable for your own actions in the way that you make decisions. And so although you act as a collective body, you're each responsible for your own decisions. You're previewing something that's a little bit later in the presentation about co-fiduciary liability. So I want to add the caveat that you could be responsible for another trustee's breach of fiduciary duties if you were aware of that, and we'll talk about that a little bit more later. But generally, it's an objective standard, but applied to you directly.
Thank you.
So today I want to focus a lot on the duty of loyalty and conflicts of interest rules. And focusing on this again because it's the primary duty in California. So the duty of loyalty requires that trustees act for the sole and exclusive benefit of the beneficiaries and participants. The duty of loyalty requires undivided loyalty. So it's all about the beneficiaries, both current and future. Fair dealing. So you must deal with beneficiaries fairly. There's no favoritism. Participants and beneficiaries should remain reasonably informed. You should communicate all material facts to participants and beneficiaries. And then no self-dealing. So no transactions involving the trust, no transactions for the purpose of personal gain. You should avoid actual and apparent conflicts of interest. And then also actively avoid future conflicts of interest. So a common challenge with boards, particularly in the context of public pension boards, is this two-hat issue. And so what I mean by that is that board members in their personal life or in their professional capacity might wear different hats. And so you could be a representative of a stakeholder group. You could be a representative of an employer. A fiduciary could be a participant or wear some other hat in their day job. And this can be really confusing when you're making decisions on behalf of the board. And when you're applying fiduciary duties. And a common misconception in the context of this two-hat issues is that fiduciaries can kind of consider this hierarchy of interests. That's this inverted triangle there, that you can consider the beneficiaries and you can consider stakeholders and employers and other interests. But the duty of loyalty does not permit this hierarchical consideration of external interest. When you're wearing your fiduciary hat, you can only consider what's in the best interest of the beneficiaries. Full stop. Nothing else. So easier said than done, sure. And I think that's the biggest challenge with the fiduciary of loyalty is that it's very simple, but it's brutal, right? You can only consider the interests of the beneficiaries, period. So what are some things that you can do to ensure loyalty? There's your ethics and conflicts of interest policies, processes for dispute resolution. There are trustee discipline policies that certain organizations use. Education and training we've talked a lot about today, including doing this fiduciary refresher today. Board self-evaluations. Organizational culture can help support the duty of loyalty, really setting a consistent tone from the top. And then your assurance and reassurance functions like audit and compliance.
I'd like to elaborate. On that organizational culture. Would it also apply for board culture as well? Would that be applicable as well? Because
Absolutely.
And how would you envision that?
So the important thing for board culture, and it's like you wrote this presentation for me.
No,
I'll cover this a little bit more later. But you as a body are responsible for your own governance, and so you set your own behavioral norms and processes. And so it's important to achieve alignment as a board about your culture and how you're going to govern this organization and do so that's in a manner that's consistent. So those involve things like moving, civility and decorum, coalescing around a decision, moving forward in a uniform or unified direction, decision discipline. There's so many different things that support board culture, and we'll get into some specific examples on my last 2 slides.
Thank you very much.
So the duty of impartiality requires a balancing act. And as I mentioned earlier, impartiality is actually a duty that derives from the duty of loyalty. And it requires impartiality among individual participant groups. So this is the no favoritism rule. So you can't favor a certain participant group over another. And it also requires income productivity, which means that fiduciaries need to invest and administer the trust both to produce reasonable and appropriate income for the present and also for the future interest of the beneficiaries of the trust. And the duty of impartiality applies to the whole portfolio and not just individual assets. So the bottom line with the duty of impartiality is that fiduciaries cannot overlook the interest of some beneficiaries or favor one beneficiary group over another. Your beneficiaries are a diverse group who have different present and future interests. So you might have a beneficiary who is a 25-year-old new employee, and you might have a beneficiary who is a 101-year-old annuitant, right? Those two individuals have very different interest. They have different exposures to present and long-term risk in your portfolio. They have different time horizons for the growth of the trust, varying exposures to systemic risks. And so the duty of impartiality requires really a sophisticated analysis that recognizes and tries to balance all those different interests rather than just kind of lumping them all together and managing to the median interest. Yes.
So as you're talking about this duty to be impartial, my brain immediately goes to investments, but this applies to every decision we make. So on the healthcare side, for example, and when we're in performance compensation meetings and audit meetings, it applies to everything that we do, not just the investment piece, which is where my brain usually goes.
Correct. It applies to everything that you do. Okay. And I think the important thing to remember about the duty of impartiality is it doesn't mandate equality. What it requires is that you consider all these different interests and you weigh the different interests and that those considerations inform your decision. So there's a Supreme Court decision that I did quote on the slide, the Verity v. Howe, and this is the first Supreme Court decision that really recognized a pension's need to preserve assets to satisfy both the future obligations as well as present claims, and to take impartial account of the interest of all beneficiaries. And so Verity is also an important Supreme Court decision because it's the first decision to recognize the importance of time horizons in the fiduciary analysis. And it reinforces the overwhelmingly long-term nature of pension fund obligations, and that long-term considerations and time horizons should almost always be considered and balanced with short-term needs. So back to your earlier question about conflicts of interest. Again, really simple, but brutal, right? It's a simple concept, but the reality of how it's applied is really challenging. So there are a number of different conflicts of interest, and this slide highlights a few that might be common in your world, and certainly conflicts of interest that I've seen in my experience working with different boards across the country and even abroad. And so the first one is financial conflicts. This one's pretty obviously, basically, you can't line your own pockets. There are protocols in place for personal investments. There are restrictions on gifts and other compensation that are prohibited. So this one's pretty straightforward. You can't make decisions in your fiduciary capacity for personal gain. The second one is stakeholder conflicts. So you see plan sponsor conflicts arise in the context of underfunding pressure. We did some research on my team in advance of this presentation to see if there were some cases that would in California and elsewhere that could provide us with some interesting guidance. And most of the duty of loyalty cases really involved outright fraud. Which is that is an easy one. That first one, you don't line your own pockets. But some of the other cases on duty of loyalty were more complex, and a lot of them involved these stakeholder conflicts. So underfunding pressure, actuarial decisions. So, for example, where an employer wants to reduce a payment or delay a payment in order for the plan sponsor to meet their budget goals, or where there's pressure to make a politically motivated decision. Serving two masters is a great way to disappoint both, right? And you just can't do it. It's a breach of the duty of loyalty. So plan sponsors, unions, beneficiary groups, they're all going to have really strong opinions about what you should be doing, but they have no accountability for what you do. You do. And so it's important to myopically focus on the beneficiaries and the members.
So hold on,
And
Jose.
I'm sorry.
Are you gonna, I just, who talks first? Oh, okay, I'm sorry. I had two mics on, so I wasn't sure.
I do want to just mention, when you mention accountability, can you elaborate on that? They don't have any accountability, these groups and so forth.
So what I mean is that there is always a lot of noise, right? There are a lot of externalities that are trying to influence pension decision-making. This is the whole reason why you have your constitutional provision on the primary duty. So there are always external groups that are having strong opinions about what you should be doing and how you should be doing it. And what I mean about the accountability is that they're trying to direct your decision-making without having accountability for the consequences of your breach of the duty of loyalty. So it's going to be your name on the other side of the V, not these stakeholder groups, if you breach your duty of loyalty. And so just putting up a finer point on that.
Thank you for elaborating on that. Appreciate that.
Other conflicts of interest, for example, involve employment or professional conflicts. I mentioned before having dual roles. If your day job benefits from your board role, that's not alignment. That's risk. That's fiduciary risk. So it's important to remember that when you're wearing your fiduciary hat, you're making decisions for the beneficiaries and not for any other reason. Obviously, employment with a vendor is prohibited. There's also restrictions on post-service employment. And so those are examples of employment conflicts of interest. Political or organizational conflicts. This is kind of similar to some of the stakeholder conflicts we talked about before, but external pressure to act in line with external groups, special interest groups, all those other groups that are trying to influence the way that you make decisions for the trust. But again, this is why in California you have that primary duty rule, which was enacted specifically to avoid meddling or political or special interest, or the influence of political or special interest on the affairs of the pension fund.
Tiffany, I just want to let you know, in the state of California, we are required to take ethics training that covers all of this and annually. So I'm not saying don't go ahead with it. I'm just letting you know that we have some very particular laws here that are even, I think, more stringent than what you're talking about.
Yeah, absolutely. So hopefully you're well informed. This slide is really intended to to tie this into the duty of loyalty and why those ethics practices or that infrastructure is created to ensure your compliance with the duty of loyalty. Just touching on the last two briefly, family and close personal relationship conflicts of interest. This one's pretty straightforward. You can't indirectly benefit from a conflict, so you should just avoid this position altogether. I have actually seen this come up several times in my career, issues of nepotism, issues of indirectly funneling money to a family member. The bottom line is you can't do it, as you learned in your ethics training, and makes Thanksgiving a little bit awkward, but it's it's better for you to not even engage. And then finally, use of confidential information. If you gain insider information in your role as a board member, you can't use it for any other purpose. So the point being that conflicts of interest can take a number of different forms, but the bottom line is that when board decision-making is influenced by anything other than the interests of the members of the beneficiaries and participants, then you have a fiduciary problem. The framework that I've been referencing throughout this, the what, why, how, that's why the why piece is so important. That's the duty of loyal piece. Why are you doing it? It's like a toddler. Why are you doing it? That question is going to guide you to the right answer.
So I have a quick question on why we're going to do it. So for example, I'll just use our RCP, for example. We have lots of constituents that push us to do certain things. That may or may not fit within our fiduciary duty. So if there's for example, we are doing a whole process to see if some of the things they're asking for does fit into our fiduciary duty. So that kind of stuff, that why, if we end up saying yes to it, then that why would answer that, correct? Since we're doing a whole process to investigate whether or not this falls within our fiduciary duty.
Yeah, I think that the issue is that the goal has to be aligned with the duty of loyalty. So if you're doing that to appease an outside interest group, then that likely is not aligned with your fiduciary duties. But if you're doing it because you think it's that this certain practice is in the best interest of the participants and beneficiaries over the long term, that you're going to have improved investment results, or you're going to have less risk in your portfolio, and those are your goals,
Right.
then that is aligned with the why. So the question is, again, back to the toddler, why? Why are you doing it? If it's because you think it's in the best interest of your participants and beneficiaries, if I can talk, then it's aligned. If it's for appeasing an outside interest group, then it's not aligned.
Right. And then the discovery behind that, the actual work that we do behind that would also be your evidence that you've done all of that for fiduciary duty, one way or the other.
Right, that your
Yeah.
diligence is informing your
Diligence,
decision
thank you.
and not vice versa, right? And so if you're making a decision for the benefit of special interest groups and not understanding how that impacts your portfolio, that's a pretty straightforward breach of your fiduciary duties. But when you are undertaking a process to understand the impact of the decision you're making, that is better aligned with your fiduciary duties. But again,
Exactly. Yes.
there's two steps here. The first one's the what are you doing and how are you doing it? But the primary step is the why are you doing it?
Okay. And I just want to remind everybody, when you're done talking, turn off your mics so I don't think that you still want to talk. And also, I'm being told we need to talk into the mics. So thank you.
Just to add on to that too, Ms. Taylor, RCP is actually a great example. The entire reason why we're going through the market study that the investment committee approved was to ensure that any potential changes we make align with the board's fiduciary duty. So our stakeholders from labor are very interested in the conditions of of the workers and their members, and that makes perfect sense. And the board is as well. But the ultimate purpose that the board always has to keep in mind, as Tiffany's been saying, is what's in the best interest of our fiduciaries, what's going to ensure that we can pay those promised benefits. And the market study is going to help us understand whether additional changes are prudent or not.
I was trying not to get too into the weeds, but yes, thank you.
So this slide just puts a final, I'll just touch on it briefly, puts a final point on the duty of loyalty issue. And that's this I single, which is from a case from like 1957. It was like one of the first cases, ERISA cases, to address the duty of loyalty. But the important point in these examples are trustees that found themselves on the other side of the V for various duty of loyalty issues. And, these cases involved, dealing with trust assets for the benefit of a third person, including a plan sponsor. The last one was a breach of the duty of loyalty because the board was considering the interest of the union as opposed to the interest of the beneficiaries, and that what benefited the union informed their decision making. And then American Airlines, which is the most recent, Spence versus American Airlines is the most recent case that we have under ERISA on fiduciary duties. It's from February of, or January of 2025. And the key issue here, or key finding, was that the board found a breach of the duty of loyalty because of the impact of outside influence on their decision making, and because they were considering other interests in addition to the interests of the beneficiaries. And so again, it's simple, only the beneficiaries.
So can I just ask a question there? Was that a defined benefit or a defined contribution case?
Spence versus
The
American Airlines.
American Airlines, yeah.
That's defined. I think that one's a DC plan. No, I think it's a DC. I think there's a. I'm actually not sure. It's an ERISA case.
Okay, just the dynamics are a little bit different with the two. That's why I'm asking.
Yeah, I mean, but the duty of loyalty is the same
yeah,
for whether
understood.
it's you're selecting a menu of assets versus actually investing it in your discretion. But again, it's an ERISA case. It's in one jurisdiction. But I think the important point is that the consideration of outside interest is what led the court to find that there was a breach of the duty of loyalty.
And is that a good example of us finding guidance and looking at guidance? Because even though it's ERISA, it could have it could be applicable to the public pension systems here.
Yes.
Is that correct? Or okay, thank you.
Let's skip ahead here. We talked a little bit about the training that you do at CalPERS, so I won't really touch on these, but you do have your ethics training, which will go into a lot of detail. But the important thing to understand is that you have a robust governance infrastructure, you have a robust processes around conflicts of interest, around ethics training, and then also around compliance and managing personal conflicts of interest. And so if you have any questions about the process and procedures that and policies you have in place, of course Matt and Robert can answer those questions for you. So I alluded earlier to this what, why, how framework. And I think it's just a really simple way to distill your duties down and to kind of guide your decision making. What are you doing? What is being proposed? Why are you doing it? Or why should you do it? And again, if your answer is anything other than because it's in the best interest of the participants and beneficiaries, then you have a fiduciary problem. And then finally, conducting the diligence. That's the how step. How are you implementing that? How are you defining, how are you structuring your process? And you have an obligation to make sure that your process is prudent. So let's move on to our last fiduciary topic of the day. And that's the responsibility that you as trustees owe to each other. And so this is a topic that actually I find doesn't really get covered that much in fiduciary trainings. But it's important to know that board members owe a fiduciary duty to each other, and that you can be held liable for the conduct of other board members. So co-trustee liability is a concept that derived from court cases, and it's even actually codified in certain states. So basically, it requires board members to actively participate in the affairs of the trust. This is both a duty and a right, which means that trustees should be able to ask questions and receive information. Trustees generally cannot be excluded from decision-making. Co-trustee responsibility also requires reasonable cooperation. And this means that trustees are required to maintain an effective working relationship. It requires, to your earlier point, a basic level of civility and decorum, setting the tone from the top, demonstrating that civility and decorum. And then importantly, trustees are required to self-govern and can be held liable for the conduct of other trustees. So if another trustee commits a breach of fiduciary duties, the other trustees should take reasonable steps to remedy that breach. In a few cases, there's only a few cases on co-fiduciary liability, and most of them are pretty old, but this Ball case that I cited on the bottom of the slide, the court emphasized that co-trustees have a responsibility to conduct themselves in a spirit so as to foster a spirit of mutual trust, confidence, and cooperation to the greatest extent possible. So I mentioned this earlier, but again, it's important to remember that a board acts as a collective body, not as individual actors. This governance construct is designed to provide intellectual diversification and collective knowledge, which is viewed as preferable to individual decision-making. So even in other organizations that I work with that are sole fiduciary models, they have advisory boards. And the rationale for that is that the collective decision-making provides the guardrails for a more optimal decision-making process. It controls for risk, it controls for groupthink, and it accounts for the limitation of individual knowledge and perspective. So to your earlier point, trustees have an obligation individually to act with care, loyalty, and good faith in participating in board activities. And no individual actor or director has the authority, unless they've been delegated that authority, to authorize any action, to direct management or other employees, to bind the organization, or to speak on behalf of the organization. So with co-fiduciary duties in mind, I'm just going to briefly touch on my last two slides. I'm going to talk a little bit about effective board behavior. Sure.
Real quick, can I ask you a quick question regarding the co-trustee breach? And in your slide, it says, the second bullet, that if a breach occurs, trustee must take reasonable steps to compel co-trustee to remedy the breach. So reasonable steps, that's a broad. Could a reasonable step be just simply to alert our office or our legal office or our compliance office or someone in the hierarchy of the breach and not necessarily confront the co-trustee? Can you just elaborate a little bit about what reasonable steps would be?
So I'm not going to respond to a hypothetical, because what's reasonable is contextual, and it depends on what the breach is. Is somebody, funneling money into their bank account and it's bleeding and you got to deal with it now? Or did somebody, share confidential information? The way that you would approach that would be differently. But reasonable steps, the assessment of that is going to be contextual. But obviously engaging counsel early in the process and having that conversation with counsel would be likely be determined to be reasonable, and then counsel can kind of guide you on next steps. And a lot of times you're going to have policies, practices, historical approaches to it that are going to guide how you deal with the situation. When I've been involved in trustee breaches in the past, usually the first step is consulting counsel, and then they can guide you through what your policies and practices are, and what the best way to remedy that situation is, because it's going to be different depending on the facts and circumstances.
Yeah, that's helpful. Thank you. I was just trying to get my heads around, what would be reasonable. And also, just like any other investigations, if they're not found to be a breach, what's the recourse of the trustee? Can then the trustee end up litigating the case against the initial, or is that, I would not say permissible, but it's sort of like expected. You know, I did my fiduciary duty to report it. Now it is incumbent upon the investigation to determine whether in fact there was a breach or not. But can someone come back and try to hold me accountable for reporting?
So that's state service, right? When you're doing an investigation within state service, retaliation is strictly prohibited. Just FYI.
Yeah, I was just curious if there was any, if you give us any.
So,
Frank,
thoughts
let me try and respond to that. The short answer is usually not. If somebody alleges in good faith that another board member, for example, has breached her or his fiduciary duty, it's investigated and found that that was not in fact true, there's almost never any kind of remedy for the trustee who the allegation was leveled against. It's just kind of, hey, you made it in good faith, turned out not to be true. Now, if you're not in good faith, there's other issues, but that's the general rule.
All right, thank you.
when,
Yeah, question on that also, just related, is a single member's communication with you or any other representative privileged?
the answer is, and Matt can talk about this too, is it depends. And so the client for the lawyer is the organization, not the individual staff member, trustee, executive. And so there can be privilege vis-a-vis third parties or privilege or confidentiality internally. And so the facts and circumstances would depend on the real facts of that hypothetical. But I think it's important to understand that when you're dealing with any lawyer for an organization, whether outside counsel or in-house counsel, that's dealing with an organization. Their client is the organization.
Okay, and so your role would be as part of the organization. You would be considered part of the organization if we're engaging you for our fiduciary counsel.
If you're thinking about it from an attorney-client privilege perspective, the client is the organization.
Okay.
And the board, as the highest level authority in general, holds the privilege. And no one board member would be able to decide to waive it, but the board collectively.
No, I'm talking about for the individual board member. So going back to Frank's original question, not wanting retaliation, could the board member ask for confidentiality or privilege?
There could, depending, it's going to be facts and circumstances, but there could be situations where that confidentiality would be protected. And I think that's the general approach as well. And I would just also add that to elaborate on Frank's point a little bit, that protection would apply even in the context of the entire board taking action. If there were a number of facts out there that had a particularly unfortunate appearance and the board chose to take action, that could be entirely reasonable and defensible and wouldn't necessarily put the board at risk of liability for taking action.
Okay. Thank you.
So just touching on my last few slides, and then we'll move on to Robert's piece of the training. So back to kind of how do you execute on your fiduciary duties? What are effective board behaviors and what are ineffective board behaviors? These ones are pretty straightforward. I see, a lot of these behaviors represented here today, that actively listening with an open mind, including an awareness and consideration of bias and how bias impacts your decision making. Showing respect for co-directors, executives, and employees, asking constructive questions, promoting discussion and debate, including through the exercise of self-control. I've seen that in board meetings in my career too, where you have one board member who likes to monopolize conversations. But you are responsible for the energy that you bring into the room. You're responsible for your own behavior, and so part of your responsibility as a board member as well is exercising self-control in circumstances when that's required. Committing to working towards a consensus after an informed and deliberative process. Sometimes things don't move your way. The group doesn't agree with your decision making, but your goal is to achieve consensus and move forward in a unified direction. And then once you've made a decision as a body, supporting and not undermining the decision that's reached by the full board. We talked a lot today about conflicts of interest. It's important to identify and disclose conflicts of interest, recuse yourself where it's appropriate, and Matt and Robert can be a tremendous source of guidance on how to do those things. Protecting board confidentiality. Avoid acting or speaking on behalf of the board without authorization. And then also raise any concerns in an open and transparent manner. Remembering that no individual board member has the ability to act on its own behalf, that you're acting for as a body collectively. And if you have an issue, you should be discussing that as a body. What are some problematic boards' behavior? I give a presentation called Boards Gone Wild to some of my clients, and this is the one of the came out of several circumstances I've seen over my career. But the first one is failing to abide by board policies and protocols, abrasive, abusive, disrespectful words and actions, monopolizing discussions, unduly interfering with management operations and delegated discretion, staying in your lane, right? It's important to understand what's in the board's lane, what's in the lane of staff. It's important to have really clear lines of authority. Leaking confidential information, failing to disclose conflicts of interest or acting on a conflicted basis, and then just a general breach of fiduciary duties or failure to comply with the laws, failure to comply with any of the practices that we discussed earlier in the presentation. The important thing is to remember that boards are self-governing bodies, and that you collectively set the standards of behavior. You collectively set the behavioral norms for this body, and you set the tone from the top. And your culture is defined by the worst thing that you tolerate. That's just for free, you guys. Your culture is defined by the worst thing that you tolerate. And so the buck stops with you. And so you set the tone from the top. So what I find is that highly performing boards have clarity about understanding the rules of engagement. What are the rules of the road? What are the expectations? And defining the structures and processes that govern the way that they make decisions. Culture, we've talked about this a lot today, setting the tone from the top. Culture is about establishing and adhering to these behavioral norms and holding each other accountable for the behavioral norms. Accountability requires effective self-governance, controlling the controllables. Boards are collectively responsible for their own effectiveness, and you want to model individually and collectively the culture that you want to have as a body, and hold other members accountable when they're not aligned with that culture or not acting in alignment with the culture. And then the last thing is consistency, right? Of all the above: culture, clarity, accountability. High-performing boards achieve alignment by doing this work consistently, day in, day out, small moments over time. And good governance is not a panacea. It doesn't cure all ills. There's always going to be, externalities, personalities, and circumstances that challenge a board and challenge an organization. And you just can't predict all of those things. You can try, but you can't predict the future. But what you can do is make your organization more effective and resilient. And good governance practices will insulate you individually and as a body, and other fiduciaries from collective and personal liability. So with that, thank you for your attention. I know that was a lot of information, and Robert is going to cover the Bagley-Keene Act.
Teresa, before we move on to Robert, can I? Yes. Probably something I could have brought up very early, but when we talk about the best interest, how narrowly do we kind of constrain our thoughts when it comes to what the interests of our beneficiaries are in terms of our mission, what we're set up for, versus the broader interests of, our members and their beneficiaries in terms of the quality of their lives, their longevity, their health, those kind of things. And just for kind of a silly example, I may feel that, it's really in the interests of our members to have more music in their lives, or more open space or parks or things, and that'll make them healthier and happier, and it'll, and investments that do that are going to really have a much better long-term expectation than all things being equal and something else. But, so it's just some thoughts on how constrained should we be about what we think about as their interest, because we get a lot of feedback from stakeholders who really have, strong feelings about the impacts of our investments on things that are one step, two step, three steps removed from, say, the short to medium horizon impact on the total portfolio's performance.
That's a great question. I might have somewhat of an imperfect answer for you. But when you think about the best interest of the participants and the beneficiaries, your primary responsibility is the sustainability of the trust. And why I say the duty of loyalty is simple but brutal is because it's a contextual analysis. And a lot of people are going to have opinions about what you should do. It's a big pool of assets, and they think about all the things that you could do with those assets. But your responsibility is the long-term sustainability of this trust to pay pension benefits. And so that's a difficult analysis that you'll have to undertake to kind of balance all these other considerations with what your core purpose is. And if it's not proximate to the long-term sustainability and growth of the trust, then it likely falls outside of the best interest of the participants. Matt is shifting in his seat, so I feel like he has something to say.
I think the answer is pretty simple. We're only looking at their financial interests. I think that's it. We're not, that may be wrong. I mean, I defer to the expert, but that's the way I look at it. We're just trying to make the most money for the trust so that we can provide financial benefits to the beneficiaries. It may be nice to provide parks, to your example, and other nice environmental things, but that's the role of other governmental agencies or private players. What do you think about that, Tiffany?
Said differently, but yeah, the long-term financial sustainability of the trust. And so, to use that example is, if you're investing in a portfolio of intellectual property rights in music that has a financial interest to the trust and that fits your portfolio from a risk return perspective, like it's the financial interest, the long-term sustainability, and that's your sole focus. And I think that one of the biggest challenges for pension board trustees is to help stakeholders understand that nuance consideration, because it's not that you don't care about music or parks or all these other things, but your mandate is very specific.
Yeah, I think, and those kind of collateral interests, simple, but not easy. And I think of a quote I once heard variously attributed to everyone from Disraeli to Einstein about, for every complex problem, there's a simple solution, and it's wrong. So it's a real, it's a difficult thing when, especially I think for me, when we all bring such a diversity of backgrounds to this. that trying to kind of level up on that really, this is really what we're here for. This is
Right.
the common, this is what every one of us, regardless of that diversity of backgrounds.
Does
that
it
brought
provide a
us
risk
here.
or opportunity? Yeah.
And and to have that, certainly openness to the other opinions, openness to our stakeholders' views, but that, when the buck stops here with us, to be focused on that sole purpose. So, thank you. I appreciate the help with that.
Yeah.
Thank you.
That's an interesting point, and just as one follow-on, I think it's that the legislature was intentional when it set your board composition, right? And the intention is that all of these different backgrounds should inform your decision making. That the expertise that's derived from where you sit, and where you stand depends on where you sit often. But the challenge is the intellectual process that you have to go to take off that hat when it's time to make the decision, and to understand what your mandate is. Your primary mandate above all other things is the long-term sustainability of the trust for the beneficiaries, period.
Thank you. Thank you, Tiffany. We'll move on to Mr. Carlin. Your turn.
Thank you, board members. Good morning. Robert Carlin from the CalPERS Legal Office. I'm pleased to be here with you this morning to give a little training here on the Bagley-Keene Open Meeting Act. And I wanted to try to do something a little bit different than some of the staff trainings we've done in the past. We'll start off with a brief overview on the Bagley-Keene Act, its main provisions, but then I want to pair that with kind of a deeper dive into a particular topic. In this case, we'll be talking about serial meetings that I think are what will be of interest. And so we'll be interested in your feedback to see whether that pairing is more interesting than just a general overview or how you like it. I want to start off my remarks by spoiler alert, there won't be anything in this presentation about how AI is going to make things more efficient. That's both because I don't think AI could make this more efficient, but more importantly, Bagley-Keene and the rules that this board has to follow for these meetings isn't intended to make things more efficient. It's actually kind of the opposite, and it's oftentimes can be a source of frustration for trustees and the public because we have to go through things in a very methodical fashion that's not intuitive. It's not natural for how we engage and interact with our peers in any other context, but it's what the law requires, and so we have to follow it. So the fundamental purpose of the Bagley-Keene Open Meeting Act is really kind of represented by what we have going on right here this morning. We've got the board all together with staff, and we have members of the public present, and they're able to sort of see the discussion and the back and forth and the decision-making live in real time. And that's what Bagley-Keene is trying to achieve. It wants to make sure that the public has a seat at the table for a number of decisions that the boards like us make, but also recognizing that there's certain decisions that it's appropriate for the board to make in private, and so the law affords that opportunity as well. Bagley-Keene operates by designating what's called a state body, and you could essentially think of that as any multi-member entity. For CalPERS, that's going to be the Board of Administration itself, its committees, any subcommittees we create. And there could even be ad hoc subcommittees that could be created. So those, anytime we've got multiple members involved, we're going to be in a zone that's governed by Bagley-Keene. The one exception is going to be when we have an advisory committee that only has 2 board members on it. That's going to be something that's not governed by Bagley-Keene. And so we do use that vehicle from time to time. But otherwise, if we've got more than 2 or more members involved in something formally as part of a committee or a subcommittee, we're now governed by Bagley-Keene, and we have to follow all the rules that apply to that. Bagley-Keene defines, thank you for that. Bagley-Keene defines what a meeting is, and a meeting is essentially when we have a majority of the members present in the same location to hear, discuss, or deliberate on any item that's within the body's jurisdiction. And there's a number of exceptions where a majority of the board is present and it's not part of a noticed meeting, and that's permissible under Bagley-Keene. Some examples of those would be when the majority of the board attends a public conference, like if we've got CalPERS or something of that sort. A majority of the board is allowed to be in the same place at the same time, provided that a majority of the board members aren't discussing CalPERS business in the process of being there. So you're all allowed to be there for that. Similarly, if there's public meetings of other bodies, whether it's a state body or local government, a majority can be there, again with the proviso that you're not discussing CalPERS business while you're all together. There's an interesting rule when we have a committee and non-committee members are present. The law allows other non-committee members to be present as well, as long as they are serving in what's called an observer capacity. It's sort of a term of art under the law. And social or ceremonial gatherings, if there was a funeral or a retirement celebration, again, a majority of the members could be there for that, provided that they aren't discussing CalPERS business in that context. And I did want to also, let me just say too, please feel free to interject with questions. This is intended to be interactive, so if something pops up into your head, don't hesitate to turn on your microphone and reach out. You don't have to hold questions until the end. In addition to our normal meetings, there's also, the law provides for special meetings, which can be called on a shorter time frame, and emergency meetings on an even shorter time frame. Both of those are pretty unusual, as any of the members who have been on the board for a while know. We very rarely, if ever, have used either of those provisions. Yeah. And I mean, the emergency meetings are intended for things like if there was a complete work stoppage or a big natural disaster. So there's affordance in the law to try to accommodate special circumstances, but by and large, we're operating under our normal rules, and those rules normally require 10 days notice of the meeting ahead of time. We've got to put out a written notice and agenda of the meeting. The purpose of the agenda is to essentially give the public fair notice about what is going to be discussed or what action is going to be taken by the board, so that they have an opportunity to determine whether or not they want to participate in that. So we've got to always itemize all the particular things that we're going to be talking about or what actions we're going to take, and we take a lot of care in making sure that we do that. Another feature of the Bagley-Keene Act that has become more topical in the last couple of years is teleconference meetings. You know, historically, pre-pandemic, teleconference meetings were particularly onerous and difficult to carry out. They allowed for members of the public from other to participate from remote locations, but they had to be a remote location that was open to the public, ADA compliant. So it was something that, as a practical matter, we and many bodies didn't use because it's difficult to find locations that meet those requirements. Not to mention, just trying to coordinate historically was difficult. The pandemic came, as we all know, and that really kind of turned everything on its head, especially with respect to public meetings, because all of a sudden we literally could not all be in the same room at the same time, and we needed to have a way to get around that. The governor originally issued essentially an executive order exempting those requirements and allowing for board members to participate from remote locations, the privacy of their home. And that's been codified in law and is still recognized today with certain requirements. We have to web stream our meetings or provide for remote public comment when we're meeting in that fashion. And so when we do have board members participating from a private location, we follow those rules. I talked early at the beginning about the ability of the public to participate, and that is a big component. The law allows members of the public to be present for all open sessions. Public comments are a requirement to be provided at each agenda item. An interesting contrast, so, you know, Bagley-Keene is the law that governs state bodies like CalPERS. There's also the Brown Act, which is what our local government counterparts operate under. It's a similar law. Courts will oftentimes look to both laws to try to interpret what one provision means, because many of the provisions are the same, but there's also some interesting differences between the two. You know, another topic near and
Mr.
dear to
Carlin?
all our hearts. Yeah, I'm sorry.
Over here. I just want to go back to sorry to interrupt
No,
you.
no, please, please.
with respect to the public comments, can you elaborate on that? So members of the public can provide us oral comments when they come to the board, but they also are able to provide us written comments and I've heard some people, not here, I've never seen it here, but at a city council meeting, somebody that did a video and gave it to the to the clerk, and they asked the board to view the video when they saw it, because they wanted to record their emotion. After the public comments are brought forward, what's the next process? I mean, as a board, we review it and then we respond. I'm just want to understand.
So your specific question is, what's the process after the public makes the comment?
No, that's part of it, but it's a process of how we as a board,
I'm just trying to get you to kind of narrow, because you asked for him to.
I think
narrow
Thank
down
you.
He got it.
question a little bit. Yeah.
No, he got it.
It's a good question. So to the first part of your question, we've never, I don't think, ever done video, accept a video submission. We typically don't accept written comments to be read into the record. Each body is going to have its own particular rules about how public comment is going to operate. The board, almost a decade ago now, adopted a public comment regulation that defines things like the 3-minute time limit, factors that can be considered, because to be efficient, to try to be efficient anyways, we do have the ability to reduce that number of minutes if we had a large number of members and we didn't have enough time to accommodate everything, that sort of thing. Some local bodies will allow for the appointment of a particular representative for a group. We don't have that particular feature, and we don't have a feature that would allow for like written submission of comments, but each body can essentially adopt those kind of rules. To your question, it's a really good question about what's the board's role, or how should the board react with respect to comments. The short answer is there's no obligation to do anything other than accept the public comment. And in fact, the board is kind of limited in its ability to respond because, in part because the public oftentimes has the ability to raise issues that either haven't been agendized or haven't been fully agendized, and it wouldn't be appropriate for the board to take action if we didn't have the right foundation in place. So I would say that my general advice would be, is just to accept the public comment and do so respectfully. We want the public to be here. We want them to provide their input, and it's valuable feedback. But it's just that, and it's something for the board members to absorb. And it's certainly something that can be considered in the context of a particular item. If there's an action item before the board and you're getting input that you think is helpful, that's something that you can consider in the context of everything that you're considering with respect to that decision.
Thank you, Mr. Carter. And as a follow-up with that, I know that we have, as a board, have provided, instead of the 3 minutes, we provided an extra 3 minutes for persons that speak Spanish or other languages, or have disabilities, for instance, that they need some sign language and so forth to provide their process. And is that appropriate? Or let's say, for instance, a person needed more time. Either they were speaking slowly or they were nervous. Do we, as a board, can provide more discretion instead of the 3 minutes? Provide maybe another minute or so.
So I would say a couple of things to that. First, when we're talking about an individual whose first language isn't English, and so they require the assistance of a translator, whether they're someone who's signing or someone who speaks Spanish and they have a translator there to translate that to English, the law requires double the time allotted for those individuals, so that's required there. Our public comment regulation gives the chair of the committee or the board president, if we're talking about a full board meeting, discretion to allow additional time for a speaker. So it's as we've all seen how these operates. If someone's going over, we'll give them a couple seconds. If they keep going, the chair will often say, "You've hit your time." But we also have the ability to grant a little bit of different time, extra time. The one limitation I would say is it needs to be done in a viewpoint neutral fashion. So we can't give extra time for the people whose input we like and say we're going to give less time for people who we don't like. So as long as we're not doing, which we don't do, so as long as we're not doing that, the chair has a certain amount of discretion to, and the chair is the public comment regulation spells this out, but the chair is considering a number of factors. They're considering additional meetings that might be taking place that day, where they are with respect to the agenda, how many additional people might want to speak. So there's a number of factors that are being considered in those situations.
Thank you, Mr. Carlin. Just that last question I have in this area. You brought out that the majority of the board can attend conferences and meetings, like you mentioned CalPERS and so forth, as long as we don't speak any CalPERS business. And we as a board, at these meetings, we have to be conscious of that, not to bring that up, and only focus on the educational items that are present to us at that time. Is that correct, sir?
That's correct. I would say you don't have to avoid one another, but what you don't want to do is be discussive. For example, if there was an action item at the next meeting, you wouldn't want to get together and start discussing that. But you could certainly exchange pleasantries and, talk to each other about how your children are doing, or, how the latest sports game went, or anything of that sort. That'd
Very
be
good.
fine.
No, I just wanted some clarity on that. Thank you so much.
I have a question.
And just real quick, I hope fellow board members don't think I'm especially antisocial at events where we're all there, but I just, the suspicions that people have when we're together or something. So I sometimes often is just kind of make myself relatively scarce in some of those opportunities at some of our offsite events or trainings or conferences, just for that reason. But to my question, do you have any particular advice for us in terms of the electronic formats? For example, social media and stuff. Is there anything we need to particularly, because we never really done any training that I'm more specific to that, but it's pretty clear what, for example, a serial meeting or communications that could be seen as being inappropriate in terms of, as a committee chair or a member to my other committee members, but on other platforms, say social media, Instagram, Facebook, Discord, or whatever, is there anything we should particularly be careful of to not be viewed as kind of trying to guide things or telegraph things outside of the public meeting setting?
It's a great question. I didn't have a particular slide on it, but I do have some information to share because I thought this might come up, or I have a bullet on it, but this is as good a time as any to talk about it. So social media in particular, so all electronic platforms create additional and probably greater risk of potentially having a serial meeting. The simplest example would be if there's an email from a member of the public to the entire board, and you as a board member see that, and let's just say you immediately think like, this is wrong and I need to be on the record about it. Hitting reply all to that email and copying all your fellow board members is putting you and the board in danger of a serial meeting violation. So it could be as simple as that. Social media also creates a number of potential footfalls that we want to try to be careful about. The Bagley-Keene Act hasn't directly addressed that yet, but going back to my earlier comments about how courts oftentimes look to the Brown Act, the Brown Act did adopt some legislation a few years ago, AB 992, and it took sort of an interesting path with respect to social media. I mean, I think we as lawyers had always advised to be very careful and not interact with your fellow members on social media, just to be extra prudent and careful to your comments about being, not necessarily interacting in public session or in offsite settings and things like that, David. And what AB 992 essentially says is that board members are, in the Brown Act context, are allowed to interact with members of the public. They're allowed to talk to them, ask for information, all the kind of engagement you'd normally see, but they are prohibited from responding directly to their fellow board members on those platforms. So a few years ago, I would have used the example of Twitter, but it's now called X, and it's hasn't become the most hospitable place, let's say. So the example I would use now is Blue Sky, for those of you who are familiar. It's kind of a place where a number of academics and others have gone to in light of Twitter's current state of affairs. And it raises some interesting questions. Interesting probably only to lawyers like myself maybe, but nevertheless, we'll talk about it here for just a moment. So you're on Blue Sky, you have an account. You wouldn't want to boost or like or repost a post from one of your fellow trustees. It's not technically violative of Bagley-Keene, but given that we have this Brown Act law in place, if there was someone suing the board or a board member over a serial meeting violation, I think courts would look to what does the Brown Act have to say about this, given that Bagley-Keene is silent. So I think that'd be prudent. But it does raise, to your point, you mentioned like Discord, which allows the creation of like a private, or it could be a public like chat room, but it's not open to the entire public. The example I was thinking of in the context of Blue Sky is Blue Sky, like Twitter, enables members to communicate privately with one another. So like if I have an account, I could talk to somebody else and send a private message, almost like an email effectively. The interesting question from a lawyer is, Blue Sky is a social media platform. It's governed by this rule. If one board member messages another privately, is that a problem? Now, I'll get into more detail about what that looks like when we talk about the serial meeting rule, but it's not clear on its face. So normally I would say not a problem, but it's not clear in the AB 992 context exactly what a court would say about that, given that board members are prohibited from interacting directly with one another in the Brown Act context. So that's a little bit about that. Happy to elaborate further if you have further
Yeah, we're gonna have to, that's a whole different,
Whole different training,
yeah, that's a different training, I think.
not to mention Signal or anything like that.
Because liking something or messaging somebody on text, I mean, that's two people, right? We're not messaging the whole board. And that's where we fall under. I don't know what the Brown Act does, but that's where we fall under, as long as we don't have, what is it, 3 or more?
So it's as long as it's not a majority. So we'll get into that a little bit
Yeah,
further with the
so-
serial meeting context, but
And I do have other questions, so let me move on.
Okay.
Mr. Palkey,
My question seems.
lean towards your microphone, please.
Thanks. Yeah, I'm gonna pass on my question because I'm enjoying the conversation that's going on right now.
Okay, Ms. Gallegos.
Thank you. So you mentioned earlier items that are not agendized or action items that have to be noticed. How do we, as a board, what are the rules if something should occur between the time the agenda is published and our meeting? So let's say we have a major crisis in the markets and we need to be able to provide Stephen some latitude in his management of investments or make a crucial decision. How do we get that on the agenda or be able to discuss that either in open or closed session, should the case arise?
so there is a provision within Bagley-Keene that so if we've already got a meeting scheduled, let's say, and something happens between when the notice is posted and the meeting, something that we had no inkling of and that creates a really dramatic need for some type of action or direction from the board, there is a provision that procedurally would allow the board to add that to the agenda for the meeting. And there's a vote required, and I believe the vote requirement is 2/3. So 2/3 of the members would have to essentially vote and agree that this incident came up, that it wasn't something that was known to the board before the meeting, and that there's a need for immediate action to be taken. And then that can be added on to the agenda. So that would be the vehicle by which it would be done. But if there isn't a meeting scheduled, we're left to the normal meeting types that are out there. We'd have either a 10-day notice, or if there was something that fit within the special meeting, that allows for 48-hour notice. There's not a provision specifically for like dramatic events in the market, but staff would obviously be looking for what potential vehicles might fit to address the situation.
Mr. Carlin, I just want to remind you, we got to kind of move along. We're supposed to be done by 10:20, and I know you got a whole 10 more or 9 more slides, so.
Not to worry. Yeah, we're ready to move right along. And these will go quickly. I designed this intentionally to be flexible so that if we were short on time, we could go through it relatively quickly. So we talked about meetings, when there's a meeting. The serial meeting rule really grew out of the fact that board members historically were trying to get business done, or were getting business done outside of a meeting. And the serial meeting rule is designed to prevent that and ensure that all sort of deliberative and actions are taken in the context of a meeting and not allow for them to happen outside of the meeting. So a serial meeting is anytime there's a series of communications among a majority of the members of a body. So it's not just the board, it could be in terms of the committee, where you're discussing, deliberating, or taking action on an item of business. I've got the legal prohibition language on here just for your reference, so you have it. But the key point to what we were talking about earlier with some of the back and forth, this applies to all communications: email, text message, phone call, personal face-to-face interactions. All those could qualify for this. And so there's two types of serial meetings. Traditionally, there's variations on this, but these two are the fundamentals. The first is what's called the daisy chain, and I tried to create this in the context of what it would look like for a 7-person body, as some of our committees are set up that way. So the whole idea of the daisy chain is member A talks to member B, who talks to member C, who talks to member D. In the context of a 7-person body, 4 is a majority. And if that kind of a communication happens discussing business before the committee, we've potentially got a serial meeting violation right now. So a critical sort of rule that I have a later slide that just mentions, a good practice for board members is really, if a safe harbor, if you will, is what I call the rule of 2. If you're just talking about things with one of your other fellow board members, you're likely to never run afoul of these particular rules. But if you don't, there's danger. And it's pernicious enough that member A doesn't have to know that member C is talking to member D. So it's not necessarily not just a situation where there's an intentional, let's try to get around the rules, but even inadvertent as well. So it's part of why we have to be really careful.
I will suggest, if you are in doubt, ask Robert.
Yes. Yeah, myself or Matt,
Yeah,
both of us are
well,
happy to address these type
We
of
can't ask Matt anymore, man. I'm sorry.
We've got him for a little longer, unfortunately.
That's true.
I'm glad to say. But yes, no, the time is dwindling. So if you have any last-minute questions you want to get Matt's view on, make sure you ask them soon.
Okay, Mr. Rublikoffa, go ahead real
Thank
quick.
you. Yes, I have a question. The serial meeting, in your previous slide, you talk about there has to be discussion, deliberation, or take action. In a further slide, you mentioned that I'm talking about electronic communication, emails. You mentioned the best practice is to avoid reply all. But my question is, what if you're just sharing public information? I mean, I know the best practice should be.
Into
and
the
I learned
microphone,
thanks
please.
I learned, thanks to Matt, that we should just send it to the executive office and they'll take care of it. I know that now for best practice. But if it's just sharing information that's public and there's no discussion, deliberation, or action, why would that be wrong?
So the reason why it would be wrong is that the law recognizes that it's not just when you're ultimately taking action that matters, but also when you're cogitating on it, let's call it, or when you're thinking about it. And so even just sharing that kind of information, this goes to my earlier point about Bagley-Keene's not necessarily efficient. It'd be more efficient, to your point, to share that information with your trustees ahead of time so they could think about it and then have a discussion. But the law doesn't allow for you as a board member to share it with all your fellow trustees. That's why we have that process in place where if there was an article or a new think piece on something, you would share it to the executive officer. The executive officer would then make a decision whether or not to distribute it to the rest of the board. That's intended to avoid any potential for a serial meeting violation.
Thank you.
Still gets out there.
Yes. The second type, going quickly now because I know we're very close, hub and spoke. This is the second type of serial meeting violation where you have one member who's acting as the main conduit to everybody else. And here I used a 9-person body. We also have some of those as well. In the context of a 9-person body, if 5 members are communicating together, that's a majority, and that would also be a violation of the serial meeting rule. So if member A is coordinating with all these other members, and these other members don't have to know that member A is necessarily doing that, but if member A is doing that, that's potentially a serial meeting violation rule again, also.
That's very inefficient, especially if you don't know you're doing that.
Yes.
Anyway,
yeah.
go ahead.
Then just quickly, some exceptions. So it's not a serial meeting. First of all, members of the board have the right to have contact with members of the public individually and to discuss things with them. The important thing I think you want to always make clear is you you are not wanting or receiving information on your fellow board members. So you don't want to be talking to a stakeholder or a member of the public and they say, no, I've already talked to Frank and I've talked to David and I've talked to Teresa. You say, I don't want to hear about them. I want to hear what you have to say, but I'm not looking to get any information on what my fellow trustees are doing. The second exception is staff briefings, which we regularly do. Those, Ramon, to your point, are designed to help inform the board, answer their questions, so that when we do have a meeting, you've got a proper foundation to discuss and take action on things. Those kind of communications with staff are permitted and not a problem. The law specifically provides that when it's individual trustee to staff, there's no violation of the rules, and there could be a dialogue, information being exchanged, questions answered, et cetera. Consequences of a serial meeting violation. If it's intentional, just like other Bagley-Keene violations, there's misdemeanor criminal liability potential. Now, there's no recorded example of those. It's a difficult thing to prove, but nevertheless, I think it's part of why we always want to be mindful about that, because that potential exists out there. Civilly, there's the potential for action taken to be reversed. We could be litigated against if there's a violation, and not unimportantly, if we lose, we have to pay the attorney's fees of the challenger. So we want to be very careful, and we are. I'll skip the examples just because we're right up on time, but you have those there for your reference. Best practices, as I said, avoid discussing matters with more than one of your colleagues outside of a meeting. That's a good practice. Not something you have to always follow in all cases, but you'll be safe if you follow that. You don't want to use staff as a conduit. You can't get around the rule that way by having staff do the communications. Avoid reply all. We talked about social media already, so be careful on social media and reach out to us if you have questions about that. And we're right at time, so I'm happy to take any last minute questions or take them after the meeting as well.
Anybody? Oh, there you go, Frank. Go ahead.
Thank you, Madam President. Real quick, closed session. I want to ask you a question real quick about, we approved, the closed session, we as the board, to go into closed session. And of course, we do that on the advice of counsel. So back to process. We talked earlier about process. So in my thinking is I'm meeting that process. The process of legal counsel told us that we are in good standing. We are fulfilling 1126 and we complying. So certain things, are obvious. For example, cybersecurity briefing, obviously we got to do that in closed session, or some of the other ones are outlined because for fear, we don't want to tell the bad people, oh, here's what we're doing. But other things such as, for example, and I'm using that very generically, a contract negotiation, after being vetted by legal and determined that it's okay to speak that in closed session, we are meeting the process threshold, aren't we?
I think that's exactly right. This goes back to whether it's a prudent delegation. So I think as long as the delegation to your staff, which you're relying upon for the entire agenda, right? You're relying on the fact that we've properly agendized everything that the board's going to be talking about, both in open and closed session. And to the closed piece, that's exactly right. And, you've made a prudent choice of your general counsel and your legal staff and relying on their input and advice that everything is kosher for closed session. You've met your duty as far as that goes.
Great. Thank you.
Thank you. I have one public comment from Mr. Darby, if you want to come up to the microphone. Hi, Al. Long time no see.
Al Darby, Vice President, Retired Public Employees Association. There is a fiduciary question around investing in affordable housing. It has potential conflicts that will call into question the viability of this unconventional investment. That is, its uncertain nature, its uncertain components such as federal and state grants and regulatory issues in the various states and so forth that it might show up in. The straightforward nature of the investment is less reliable, and a fiduciary controversy due to the social program nature of this project. the challenges and security of the perf may be at risk here with this type of investment. One other comment, and that is, does the Supreme Court ruling on bribery make it a legal issue in some cases that our fiduciary folks here might want to have training on what is a legal bribe and what isn't? Thank you.
Wow. Okay, thank you. I will thank our panel, Tiffany Reeves. As always, we love your trainings. And wow. And Robert Carlin, thank you very much. I'm sure I will be calling you to make sure that we're, and my the board should feel free to call Mr. Carlin or Matt before he leaves on the Bagley-Keene stuff. Again, thank you very much. We will be moving into a break.
Thank you.
Thank you. I would like to see Tiffany. I would like to see your boards gone wild eventually. Yeah, I don't want to be an example. Just it would be entertaining.
Next year. Thank you.
Yeah, we are right here, 11:20 a.m. break.
No, we have one more session before break.
Oh, perception results. Yes. Why was I looking at it and thinking it said 11:20? My bad.
We have one more.
We are not on break. We have one more session, stakeholder perceptions. I kind of did. I kind of wanted to check out.
Whatever you want. What do you say, just real quick, 10 minutes? So people-
Hey, you guys, I'm going to go ahead and okay a 10-minute break. I know everybody needs to check out before 11 because that's what I was thinking. That's probably why I was thinking it was already 11. So before we start the stakeholder perception survey, let's take a 10-minute break. Where are we time-wise? So 10:36, if that's okay with everybody.
Thank you, Madam President. Good morning, everyone. Brad Pacheco, CalPERS team. We're pleased to be here to share the results of this year's Stakeholder Perception Survey. And as Teresa mentioned, I'm joined by Simone Parker, who leads our Stakeholder Relations team. And we also have a member of our research team here in the audience if you have any questions about the methodology of the survey. So as you know, every year we reach out to a broad group of stakeholders, including active members, retirees, employers, and to ask a fundamental question, and that's how are we doing? So the survey is really our annual temperature check on trust, transparency, customer service, and leadership. And as Ms. Parker will explain, the survey covered a number of topics that align directly with our strategic plan, and those include customer service, healthcare quality, ethics, compliance, and the strength of our policy advocacy. The results are just not interesting metrics. They are embedded in our performance framework, and we track these alongside our business objectives to see and use as a guide where we need to improve. Our response rate this year, while statistically sound, has decreased. The overall rate was approximately 6%, and you can see here from the response rate by audience segments. This next slide will show you the trend of the response rate over time, and as you've seen, you'll see it has decreased in recent years from 8 years ago. And we are working with our research team to see how we can increase participation in future years. So this year's survey was delivered between March 6th and April 1st, and it took place in a complex and dynamic environment that was shaped by a number of external uncertainties. We had a transition to a new federal administration that brought policy uncertainty. And earlier in the year, we saw some stock market volatility that heightened some concerns about the financial stability of the fund. Our 75% funded status, which was the time that the survey went out, now 79%, reflected progress, but it also emphasized the need to continue to improve. And as in the past, there have been some polarizing topics this year, including ESG, climate change, DEI, and concerns over private equity investments. The introduction to a total portfolio approach did signal a shift that continues to require careful communication to ensure our stakeholders have full understanding of TPA. And then finally, we had geopolitical risks and rising healthcare costs that further added to the complexity. So with that, I'm going to turn it over to Simone to get into the details of the results.
Thank you. Thank you, Brad. Can you hear me? Okay. Thank you, Brad. So what does this survey measure? It helps us understand, are we managing the system well? Are we meeting our customer service needs? Are we advocating for retirement security and affordable, quality health care? And are we communicating well? So the good news is the general perception of CalPERS is positive. We asked the 5 cohorts that Brad mentioned earlier, our members, active and retired, our employers, operational and senior leaders, and our stakeholder leaders, 8 long-term trend questions. These are our yes and no questions. And of the 4,507 respondents, 86.4% said yes across the board. I will say that this is a slight decrease, but only by 0.9% from last year. So this graph illustrates a trend from the last 9 years. And as you can see, there was a slight dip from last year, but in general, the positive perception rate is still in the higher quadrant of this graph. So what are our key findings? Focusing on general perception of CalPERS, the breakdown shows that our retirees are at the top with 93% saying that they have a favorable status of responding yes to the questions in the survey. We saw an increase in favorability from our employer leaders. That went up 1%, and our stakeholder association leaders went up 6%. So in general, our score and favorability scores remain high. Similar to last year, the results show that nearly 90% of respondents answered yes to CalPERS is being managed well, and CalPERS customer service is being managed well. Focusing on the same trend, our lowest favorability status remains confidence in retirement money being there when we retire, and a balance of healthcare quality, care, and cost. Yes, thank you. Both these indicators are down from last year. Confidence around retirement money when we go to retire went down 3%, and the voice on balancing healthcare costs and quality went from a 5.06% rating to a 4.9 rating, and those are on a 7-point scale. The next two slides are bar graphs showing a 6-year trend between 2020 and 2025 for each long-term trend question. The far blue line, 6 from the right of each bar cluster, represents the current 2025 results. So we'll start with our active and retiree members. The scores are all over 80% or higher. Our highest score, similar to the earlier slide, with 92% saying yes, that CalPERS customer service is being managed well, and 91% saying that CalPERS is being managed well. The overall rating amongst active and retired members was unchanged from the 24 results. The lowest scoring again this year was confidence around retirement money being safe. This decreased nearly 4% from last year. I will point out that in our outreach efforts, we do get a lot of questions on, is our retirement money safe? So this isn't a surprise to us, but it is an opportunity to continue to educate members on the security of our pension fund. Now let's look at the long-term trend questions for the employer group. This takes into consideration both the senior leaders and operational team members. Operational team members are those that would interact with CalPERS' business areas directly on payroll, membership, financial, or health issues. As a whole, we saw a slight downward trend with employer group access, employer groups across all long-term questions. This provides us an opportunity to look at ways to meet their needs. This slide shows the breakdown of responses from management to non-management. And as you can see, and based on prior year's trend, the non-management continues to score higher in favorability across all the questions. This slide outlines the general perception breakdown by employer type. These numbers are the percentage of respondents, again, that said yes to all the long-term questions combined. As you can see, school members continue to have the most favorable answer to the long-term questions, responding yes 90% of the time. Although we saw a slight decrease in favorability amongst our public agency members, our state workforce scores stayed nearly the same. So survey respondents are provided open-ended comment opportunities in conjunction with each survey question. We received a total of 4,072 open-ended comments. Like last year, most of our comments were around customer service, investment, and member outreach communication. It's not surprising that 20% of the comments are related to customer service when we have multiple questions on the survey related to the topic. I'll say that as an organization, we strive for high-quality customer service, and we use this feedback to look at ways to improve. You heard yesterday on a number of initiatives that the team is working on to improve the needs of our members and employer during the Enterprise Performance Management update. And as an organization, we review the comments to see if insights can help shape future initiatives and efforts to better serve our employers and members. Although we received comments on how to improve, most survey respondents were pleased with our customer service. The average favorability score for all the customer service related questions was 86.97% combined. Just to highlight some of the other ones for investments, a lot of the comments were along the topic of ESG, and communication was related to some saying we received too many emails, some saying we're not receiving enough emails, and others expressed an appreciation for the newsletters that we receive. So with that, I will hand it back to Brad to provide some closing comments.
Thanks, Simone. So looking at the detailed results, we see an encouraging picture. There are clear areas where stakeholders continue to express confidence in CalPERS, particularly around the overall management of the system, customer service, and the value of our long-term investment strategy. I think it's important to recognize that different stakeholder groups view us through different lenses. Retirees, for instance, often express high trust, while employers may have more pointed concerns around cost. And understanding those nuances help us tailor how we engage and support each audience. At the same time, we do see opportunities, and I think many of these opportunities were expressed in the presentation yesterday around our strategic plan and where we are with various initiatives. We will be working with the research team to talk about ways we can increase survey participation in the future. If you looked at the trends, and in particular the satisfaction scores, 8 or 9 years ago, there were more challenges with the system, and I don't want to make the assumption that the low participation in recent years means that everyone is happy, but we tend to see greater participation when more people have things to tell us than when things are a little bit better, as they are today. So again, looking at opportunities, I talked yesterday about how we're going to access more CalPERS data so that we can customize some of the communications that we're doing so members receive the right information at the right time in their career. We are exploring using an external vendor to do a full website redesign instead of just the enhancements that we recently have done. Ms. Mom talked about a number of initiatives. We're going to support her team in encouraging greater CalPERS registrations. It's those emails that we use to communicate with our members. If they don't have a CalPERS account and we don't have their email, they're not hearing from us. So it's very important that we increase more members using CalPERS. And then Kim talked about a number of AI tools that I believe are going to help her team continue to improve around customer service. I had mentioned that we're looking at all of our communication channels, evaluating their effectiveness so that we can tailor our messages to the various audiences that are on the platforms. Mr. Carlin mentioned Blue Sky earlier, so I will just mention that CalPERS does have an account on Blue Sky. We're piloting what that looks like versus X because that has changed. So we'll see where that goes. But again, we're looking at all our communication channels. And I also mentioned this yesterday that we're exploring whether a podcast might be beneficial to communicate with our members and employers. And then finally, I know the board has expressed some interest around this topic about additional opportunities that we can influence the national healthcare policy issues. And I know Dr. Moltz is going to be bringing our federal healthcare lobbyist impact back to a future meeting to discuss just that. So overall, the results tell us that we're on the right path, but it also gives us a roadmap for what's next. And I think it's a valuable reminder that the trust that we have with our members is earned, and so we need to remain committed to listening, learning, and improving in anywhere that we can. So I know we ran through that relatively quickly, but we're happy to answer any questions.
So I just want to thank you guys. This is great. The overview of the reports and a couple of questions real quick. We have a kind of an overall decrease in satisfaction, and it looks like you're trying to address some of these concerns. One thing I thought was kind of interesting, which could be bad, the more frequently a respondent engaged with CalPERS, the less likely they were to rate positively. Do we know what that's about in particular, or was it all different reasons?
I think it directly relates with the more conversations you have, you talk to different people. And so there is the opportunity where potentially you could get different answers. Whereas if you only call once, you only have the experience of the one time that you made the call.
Oh yeah, I've heard that you get, yeah. I guess having our folks that are on the phones on the kind of the same message, but it's hard because everybody perceives things differently, and we don't want robots. So
I think too, if you can ask the same question multiple ways, and it can be interpreted in different ways
yeah,
as well.
yeah. So to that though, I will say thank you very much. You guys have done a great job. How we get higher participation, I have no idea. I know we've been working on this for a while. I appreciate pursuing opportunities to influence national healthcare policies, because that's a big deal here in CalPERS, because everything they do nationally will impact our rates. So, and then the remake of the website, we've got a really open, we've won second place for the most transparent, and I don't want an outside entity to come in and not know what we need to have. We're first this year. What we need to have and where it needs to be transparent for our members.
Yeah, absolutely. No, we don't want to lose sight of all the transparency that we currently commit to. We've been working with Mr. Loveson's team to do an RFP that outlines the needs, but it's really driven by how we can create a site that better serves our members, that they can find the information. We're the most complex retirement system in the nation, and so there's a lot of information out there.
Yeah.
And so it can be difficult to navigate because everyone's circumstances are unique. But I think there's some opportunities for us, and we're also going to look at where potentially AI could factor into our future website and see if that would help.
Thank you. Thank you very much. Any other questions from the board? Oh, David, go ahead.
Not so much a question, just a comment. I do a lot of work with surveys and with organizations and how they deal with surveying and kind of the whole voice of the customer kind of thing. But one of the things that I'm very encouraged, because what I have learned is that even slightly disgruntled customers tend to be much more diligent about providing feedback about being disgruntled, or even versus raving fans tend to not be as good at responding to surveys, because they kind of expect to be raving fans even when they're, so these relatively small changes and drops, I think, the overall results are great. There just doesn't seem to be anything that jumps out as alarming. And, where those changes might be, this is not a scientific survey, so I'm really encouraged. I think it is great. The one thing I do have learned is there's a really big distinction between whether you're surveying, whether you're doing more drill down with more focused stuff, is satisfaction, dissatisfaction, and engagement are very different things. And dissatisfaction or aggravation indexes are not merely the converse of satisfaction. And so like some organizations will say, well, anything above this percentage or anything below midline or top box, bottom box, but the same instrument will not give you good information that you can use, actionable, timely info about what the dissatisfaction really is. So again, really looking at the comments, the narrative comments that can really help. But in the longer term, we might want to look at, continuing to evolve our instrument to be able to really parse out satisfaction, dissatisfaction, engagement as separate things, because I think we're kind of getting a little bit on the limit of what we can do with all this positive information is great, but I think we're at a performance level now as an organization that each gain becomes tougher because we're getting better and better and better. And so, having a more finely tuned approach may help us get those last little bits of performance that we want to get out of some of our, very high performing processes and systems.
Yeah,
Thanks.
thanks, Mr. Miller. We'll take that feedback.
All right, you guys, thank you very much. Great presentation. So we have one last session before we go into closed session. Since we had a 15-minute break, is everybody okay to move forward? Okay. So let's move forward into our action item, which is our private equity, Senate Bill 351, Cabaldon, private equity or hedge fund ownership of healthcare practices. Danny's going to talk about it for us, and then we're going to take a vote on it. Who's making the motion? Jose Luis?
Okay, good morning, Madam President, board members, Danny Brown, CalPERS team member.
Get your
and yes,
mic closer, yeah.
Okay, I'll get it. And I guess, as you know, since you see me up here, it's almost over. I seem to always go last. This is an action item asking the board to adopt a support position on Senate Bill 351. Senate Bill 351 codifies the Medical Board of California's guidance on the corporate practice of medicine to explicitly prohibit private equity groups or hedge funds from interfering with the professional judgment of physicians or dentists making healthcare decisions. The bill also includes provisions that void contractual clauses that prevent healthcare and dental providers from competing with their former practice after leaving, or from commenting on a practice's quality of care, ethics, or the financial practices of a private equity group or hedge fund. Finally, the bill authorizes the Attorney General to seek injunctive relief for violations of these provisions. I think it is important to point out that the bill does not prohibit private equity groups or hedge funds from investing in physician and dental practices. Private equity groups and hedge funds are familiar with the existing corporate practice and medicine guidelines and should already have mechanisms in place to ensure compliance. So simply codifying these existing corporate practice and medicine guidelines should not impact the business practices of PE groups and hedge funds that are already following the rules. The main change in the bill is what is being referred to as enhanced enforcement, which allows the AG's office to directly seek injunctive relief. Currently, violations of the corporate practice of medicine doctrine in physician and dental practices are primarily enforced by the appropriate governing board and may result in a referral to the AG's office for disciplinary action. We believe the enhanced enforcement should provide physicians and dentists more authority or autonomy over their medical decisions, leading to better healthcare outcomes for CalPERS members. And therefore, the team is recommending a support position on SB 351. And that ends my remarks, and happy to answer any questions.
Does the board have any questions? You want to ask a question, or do you want to make the motion?
I'll make a motion, but
Okay, so does the board have any questions before we make the motion?
Just
David.
a little bit of a question. I very much support this. I'm just curious if you had any thoughts or have heard anything of whether this kind of sort of non-compete language. I just, over the years, I've seen a lot of those kind of provisions end up being challenged and kind of jeopardizing the effectiveness of various efforts. I'm just wondering if that got tagged on late or if that was in there all along or.
And maybe I wasn't clear in my remarks, but the provision of the bill would prohibit those types of those
Oh, okay.
clauses.
Oh, my mistake. Yeah, no question.
Okay. All right, Mr. Pacheco.
Thank you, Madam President Taylor. And thank you, Mr. Brown, for your comments. I do appreciate all you've done here, and I do appreciate the enhancement of the enforcement on bad actors, and the ones that are doing their job are going to be working along with this law. So by doing that, I'd like to move that we adopt a support position for Senate Bill SB 351 as amended by June 16th, 2025.
Okay, it's been, the motion's been made by Mr. Pacheco. It's been seconded by Mr. Miller. All those in favor say aye.
Aye.
All those opposed?
Madam Chair, I'd like to abstain, please.
I was getting there.
Thank you.
And one abstention, so thank you very much. Motion passes. Thank you, Danny.
And if I may, I was asked to make a brief comment on, because I was asked about SB 41, which is a bill that deals with PBMs. And so I did just want to let the board know that we are tracking it. This bill is building off the PBM regulatory process that was passed in the Budget Act. And though that bill that's in the Budget Act does not apply to the CalPERS plan because it's self-funded. So we know that. This bill is going to build on that. And it was amended quite a bit last week. We're expecting more amendments this week as it comes out of Senate Judiciary. So we're looking at it, and it's possible that the bill as amended may capture, doesn't necessarily apply to CalPERS, but it could apply to the PBMs we contract with as being regulated in the state. So we're looking at that, and we can bring information back at the next board meeting.
We appreciate that. Mr. Pacheco, go ahead.
Mr. Brown, just want to back on the SB 351. Now that we have a support position, where's the bill now in the legislative process?
It was heard in appropriations today. I believe it was on the consent calendar. And so the next stop will be the Senate floor, but they go on a month recess starting Friday. So
it was on the consent calendar.
It's on the agenda. I didn't watch the hearing to see if it got pulled, but I was kind of surprised it was on the consent calendar because usually that's for bills that have no opposition.
Yep.
So maybe the AIC took their opposition off the bill.
Interesting. Thank you very much for sharing that.
All right, thank you, Mr. Brown. We appreciate your time and effort on this. So next up, I don't know if they're still in the room, but give our presenters a round of applause before we go into closed session. So we are going to adjourn now into closed session for items A and B from the offsite agenda. This will include the following litigation items: Cheng et al. Versus CalPERS in Sacramento Superior Court case number 23CV010718. And we will also receive the general counsel's update on pending litigation. But before we do so, I do want to, on behalf of the entire board and executive team, thank you all for your participation and attention. Notably, I would like to thank our team and guests for the excellent presentations and for traveling to be with us. The annual offsite meetings are such an important opportunity for us. They are purposely designed to equip us with knowledge that we need to make informed decisions moving forward and to share vital insights with our stakeholders. After the closed session, the board will reconvene in open session. We will then adjourn the meeting after that. So let's clear the room for the closed session. Thank you very much, everyone. And with that, this adjourns the Board of Administration offsite. I can speak. Next board meeting will be scheduled for September 15th through 17th, 2025. Thank you all for joining us. Please travel safe. I want to give board services and our communications team a big hand. Thank you very much for a wonderful offsite, you guys. Safe travels.